Yes, welcome back to the program. Now, this segment is going out live on our Facebook page as well as our YouTube channel, and we are about to discuss a constitutional judgment in the matter of private schools' badly behaved parents and their constitutional rights. The Constitutional Court judgment that a clause which allowed Pridwin Preparatory School to terminate a contract with parents for any reason was unconstitutional, has wide-ranging implications. Let's find out what all this is about with practicing attorney Matthew van der Wand. Good morning, sir, and welcome to the program.
Good morning, salam alaikum, and thank you for having me on your show.
All right, so tell us, why is this particular case such an important one in South Africa's education system?
Well, from my point of view and the approach that I took in my analysis of the judgment, it's strictly a legal issue. I've seen subsequently that there have become some sort of political and allegations being bandying about, and I think that was arising between the parents of the children concerned and the school, which was Pridwin Preparatory School, which is an elite private school not funded at all by the state. So there was clearly a long history of antagonism between the parents and the school. I analyzed the judgment purely from a legal point of view, and I think that there are a few important points which come out of the judgment, and that is, firstly, that the Constitutional Court has indicated that it is going to be applying the constitutional rights enshrined in the Bill of Rights more horizontally than it has been in the past. So there's a technical distinction between the Constitution being there primarily to protect the citizens from the state and wield of state power, and that's the vertical application of the Bill of Rights. It applies between the state and its citizens. In this case, the extent to which the Constitution applies horizontally, that is between private bodies who are not affiliated with the state, as was the case here, has been significantly extended. And how it's been extended is basically enforcing or interpreting contracts and the provisions of contracts, in this case, a contract between the parents of children and a school, through the lens of constitutionality. Which sounds fine at first blush. It makes sense. We live in a constitutional democracy. It makes sense that the Constitution should infiltrate the entire society. Where it causes or has the potential to cause difficulties is where the constitutional imperatives start to erode or intrude on the way that human beings in a capitalist society do business with each other, which is by agreeing. So in this instance, the parents and the school agreed that the school could, without any reason and on a term's notice, give the parents notice that the contract was terminating, and the parents agreed to that. And the whole issue in this case was whether or not, when the school finally invoked that clause, and the reason that the school invoked the clause was basically because the parents had behaved, just from the judgment, I don't know the people involved, but just reading what the judges said, the parents behaved increasingly like the sort of worst nightmare private school parents, in the sense that they continued to, run onto the sports field and get involved with the coaches and shout threatening things to cricket coaches. And the mother apparently wrote rude things to the headmaster, etc. And this went on for over an extended period of time. There were 2 children in the school, until eventually the school invoked that clause. The parents then went to the High Court and got blown there, and the High Court said the children have to leave. They then went to the Supreme Court of Appeal. The Supreme Court of Appeal also said, well, this is a validly terminated contract. The Constitutional Court has now last week sort of turned that around and basically held, even though by the time the Constitutional Court judgment had come out, the matter had become moot because the children had moved on to some other private school, and I assume their parents became the problem of the head of that school. The Constitutional Court nevertheless said, no, we're going to hear this, and we're overturning the previous judgment of the Supreme Court of Appeal, which, as I said, agreed with what the High Court had said, and said that the school's invocation of the right to terminate this contract was unlawful and unconstitutional and invalid. So effectively, what that has done is said that when you look at a contract now, and whether you're going to enforce a particular provision of a contract, you are also going to have to look quite carefully at the impact that enforcement of a private contract is going to have on the constitutional rights of others. Because what's important in this case is that it was the children's rights that was said to have been infringed by the school not cancelling following a fair process. I think what the court eventually said was, well, it was invalid because the school didn't follow a fair process, and therefore it infringed the children's rights to have their interests treated as paramount in the case. So it's a very interesting judgment, but and it's one of those that I think are going to have more and more effects, because my specialization is in commercial law. I draft and prepare agreements largely between private bodies, and what this judgment has said is going to certainly make me feel less sure that I'm able to tell my clients that what you've agreed to is going to be enforced and enforceable. So, and this is distinguishable from
how does two courts, I mean, the High Court and then the Supreme Court of Appeal, differ so greatly to the Constitutional Court? I mean, one would expect that a trend of law would be able to tie all of the courts together. And perhaps it's a mercy unto us that we have these structures in place, because we can always review things and take them to another level. Eventually, it will stop at the Constitutional Court. But how do we have such a dichotomy of views on a particular matter within the legal framework?
Well, that's a very interesting question, and I must say, I suppose the more cynical lawyers and colleagues of mine would say that the Constitutional Court has become increasingly a court that can give sort of surprising and more wide interpretation and application of constitutional values. And I think that tension has certainly been apparent over the years between the Supreme Court of Appeal and the Constitutional Court. But ideally, all of the courts are supposed to be enforcing and interpreting the law in the same way. You know, we exist in a constitutional democracy. The High Court has got constitutional jurisdiction, as does the Supreme Court of Appeal. So there isn't really a very good reason why you see a fair number of instances where the matter gets decided by the High Court and the Supreme Court of Appeal in the same way, and the Constitutional Court then sort of comes and puts a constitutional spanner in the works, as it were. And this case is certainly one of them where I think certainly the majority of academic commentators were quite surprised by well, the fight itself was a strange one, but because the whole matter had become moot by the time the Constitutional Court heard it. But I think there was certainly some of my colleagues have expressed a lot of surprise at the different approach which the Constitutional Court has taken, because the SCA and the High Court did consider the constitutional issues, but declined to extend the constitutional lens of the way it was looked at to the same extent that the Constitutional Court did.
Matthew van der Walt, thank you so much for your time this morning and for analysis on that particular matter. I think it's going to have, as you said, wide-ranging effects as we go forward, probably a precedent-setting case. But thank you so much for that analysis.
It's a great pleasure. Thank you for having me. Nice to talk to you.